Welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload daily at 8 a.m. Eastern Standard Time. So please like, subscribe, and click the notification bell so you can be updated every time we upload new content. Question number 1. By a writing, owner leased his home, Blackacre, to 10 for a term of 3 years, ending December 31st of last year, at the rent of $1,000 per month. The lease provided that 10 could sublet and assign. 10 lived in Blackacre for 1 year and paid the rent promptly. After 1 year, 10 leased Blackacre to Agrit for 1 year at a rent of $1,000 per month. Agrit took possession of Blackacre and lived there for 6 months, but because of her unemployment, paid no rent. After 6 months, on June 30th, Agrit abandoned Blackacre, which remained vacant for the balance of that year. 10 again took possession of Blackacre at the beginning of the third and final year of the term, but paid owner no rent. At the end of the lease term, owner brought an appropriate action against both 10 and Agrit to recover $24,000, the unpaid rent. In such action, owner is entitled to a judgment A, against 10 individually for $24,000 and no judgment against Agrit. B, against 10 individually for $18,000 and against Agrit individually for $6,000. C, against 10 for $12,000 and against 10 and Agrit jointly and severally for $12,000. D, against 10 individually for $18,000 and against 10 and Agrit jointly and severally for $6,000. Choose what you believe to be the best answer. You have 10 seconds. If you chose option A, you'd be correct, against 10 individually for $24,000 and no judgment against Agrit. An assignment is a transfer by the lessee of her entire interest. Privity of estate exists between landlord and assignee, which gives the landlord and assignee the right to sue each other since both are liable for respective covenants that run with the land. A sublease, on the other hand, occurs where the tenant transfers her rights and obligations to a subtenant for a portion of the term of the lease. A subleasee has no legal relationship with the landlord and is not personally liable to that landlord for rent. In this case, 10 transferred only a portion of the term of the lease to Agrit, so this was a sublease. As such, Agrit, the subleasee, would not be personally liable to owner for rent, so owner would only be entitled to a judgment against 10 individually for the unpaid rent of $24,000. Question number 2. While approaching an intersection with the red light against him, motorist suffered a heart attack that rendered him unconscious. Motorist's car struck child, who was crossing the street with the green light in her favor. Under the state motor vehicle code, it is an offense to drive through a red light. Child sued motorist to recover for her injuries. At trial, it was stipulated that 1. Immediately prior to suffering the heart attack, motorist had been driving within the speed limit, had seen the red light, and had begun to slow down. 2. Motorist had no history of heart disease and no warning of this attack. 3. While motorist was unconscious, his car ran the red light. On cross motions for directed verdicts on the issue of liability at the conclusion of proofs, the court should A. Grant child's motion because motorist ran a red light in violation of the motor vehicle code. B. Grant child's motion because in the circumstances, reasonable persons would infer that motorist was negligent. C. Grant motorist's motion because he had no history of heart disease or warning of the heart attack. Or D. Deny both motions and submit the case to the jury to determine whether, in the circumstances, motorist's conduct was that of a reasonably prudent person. Take 10 seconds and choose the best option. If you chose option C, you'd be correct. Grant motorist's motion because he had no history of heart disease or warning of the heart attack. The negligence per se doctrine applies when a safety statute has a sufficiently close application to the facts of the negligence case before the court. Excused violations are permitted unless the statute explicitly states that no excuses are permitted, such as strict liability statutes. One valid excuse is if compliance with the statute is beyond the defendant's control, i.e. impossibility, under a reasonably prudent standard. In this case, motorist was slowing down for the red light and behaving as a reasonably prudent driver. He also had no history of heart disease and no warning of any risk of suffering a heart attack. Motorist ended up running the red light, however, when he fell unconscious due to the heart attack. So his violation of the motor vehicle code will be excused because it is impossible for him to make the stop, and he acted as a reasonably prudent person would have under similar circumstances. So in essence, this is an argument on impossibility. Question number 3. In a jurisdiction that has abolished the felony murder rule, but otherwise follows the common law of murder, Sally and Ralph, both armed with automatic weapons, went into a bank to rob it. Ralph ordered all persons in the bank to lie on the floor. When some were slow to obey, Sally, not intending to hit anyone, fired about 15 rounds into the air. One of these ricocheted off a stone column and struck and killed a customer in the bank. Sally and Ralph were both charged with murder of that customer. Which of the following is correct? A. Sally can be convicted of murder because she did the act of killing, but Ralph cannot be convicted of either murder or manslaughter. B. Neither can be guilty of murder, but both can be convicted of manslaughter based upon unintentional homicide. C. Sally can be convicted only of manslaughter, but Ralph cannot be convicted of murder or manslaughter. Or D. Both can be convicted of murder. Take 10 seconds. The correct answer is D. Both can be convicted of the murder. Under the common law, murder is the intentional killing of a person with malice aforethought. Malice aforethought requires that the killing be committed with one of the following states of mind. 1. An intent to kill. 2. Intent to commit great bodily injury. 3. Wanton and willful disregard for human life. Or 4. Intent to commit a felony. For accomplice liability, the scope of liability includes liability for the intended crime and all other foreseeable crimes committed by the principal. In this case, we're told that the jurisdiction has abolished the felony murder rule. Nevertheless, Sally could be convicted of murder because her action of firing 15 rounds into the air while inside of the bank would satisfy a wanton and willful disregard for human life. Ralph could also be convicted of murder under the theory of accomplice liability, because a victim being shot and killed by a robber during an armed bank robbery is obviously a foreseeable outcome of the crime. As a result, the best option is D. Question number 4. Plaintiff sued defendant under an age discrimination statute, alleging that defendant refused to hire plaintiff because she was over age 65. Defendant's defense was that he refused to employ plaintiff because he reasonably believed that she would be unable to perform the job. Defendant seeks to testify that employer, plaintiff's former employer, advised him not to hire plaintiff because she was unable to perform productively for more than 4 hours a day. The testimony of defendant is A. Inadmissible because defendant's opinion of plaintiff's ability is not based on personal knowledge. B. Inadmissible because employer's statement is hearsay, not within any exception. C. Admissible as evidence that plaintiff would be unable to work longer than 4 hours per day. Or D. Admissible as evidence of defendant's reason for refusing to hire plaintiff. Take 10 seconds and choose the best option. If you chose option D, you'd be correct. Evidence is admissible of the defendant's reason for refusing to hire the plaintiff. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay is inadmissible because the declarant cannot be cross-examined when they speak out of court and without cross-examination. One cannot tell if the declarant is lying or mistaken about the facts in their statement if you do not have the opportunity to cross-examine them. Again, however, this is only an issue if the statement is being used to prove those facts are true. As such, statements offered to show the effect on the listener and statements offered to show that the declarant knows the facts that are in the statement are not hearsay. In this case, defendant is claiming that he refused to employ plaintiff because he reasonably believed that she would be unable to perform the job. As such, the statement by plaintiff's former employer that she was unable to actively perform for more than 4 hours a day would be admissible because it is not being offered to prove the truth of the matter asserted, i.e. that it is true that in fact she could not work more than 4 hours a day. Rather, the statement is being introduced to prove that the statement was made which would support the defendant's claim that he reasonably believed that the plaintiff would be unable to perform the job. As a result, D is the best choice. Question number 5. Bill owned in fee simple Lot 1 in a properly approved subdivision, designed and zoned for industrial use. Gail owned the adjoining Lot 2 in the same subdivision. The plat of the subdivision was recorded as authorized by statute. 12 years ago, Bill erected an industrial building wholly situated on Lot 1, but with one wall along the common boundary with Lot 2. The construction was done as authorized by a building permit, validly obtained under applicable statutes, ordinances, and regulations. Further, the construction was regularly inspected and passed as being in compliance with all building code requirements. Lot 2 remained vacant until 6 months ago, when Gale began excavation pursuant to a building permit authorizing the erection of an industrial building situated on Lot 2, but with one wall along the common boundary with Lot 1. The excavation caused subsidence of a portion of Lot 1 that resulted in injury to Bill's building. The excavation was not done negligently or with any malicious intent to injure. In the jurisdiction, the time to acquire title by adverse possession is 10 years. Bill brought an appropriate action against Gale to recover damages resulting from the injuries to the building on Lot 1. In such lawsuit, judgment should be for A. Bill, if, but only if, the subsidence would have occurred without the weight of the building on Lot 1. Bill, because, option B, Bill, because a right for support pertinent to Lot 1 had been acquired by adverse possession or prescription. C. Gale, because lots 1 and 2 are urban land, as distinguished from rural land. Therefore, under the circumstances, Bill had the duty to protect any improvements on Lot 1. D. Gale, because the construction and the use to be made of the building were both authorized by applicable law. Take 10 seconds and choose the best option. If you chose option A, then you'd be correct. Bill, if but only if the subsidence would have occurred without the weight of the building on Lot 1. Lateral and subadjacent support in the law of property describes the right a landowner has to have that land physically supported in its natural state by both adjoining land and underground structures. If a neighbor's excavation or excessive extraction of underground liquid deposits causes subsidence, the neighbor will be subject to liability in a tort claim. The neighbor will be strictly liable for damage to the building on the landowner's property if the landowner can show that the weight of the building did not contribute to the collapse of the land. In this case, Bill's neighbor Gale began an excavation project that caused subsidence of a portion of Bill's land that caused damage to Bill's building. However, Gale's excavation was not done negligently or with any malicious intent to injure. As such, Gale can only be found liable for the damage to Bill's building under the theory of strict liability, which requires Bill to show that the subsidence would have occurred even without the weight of Bill's building. So as a result, answer A would be the best answer. Question number 6. In a trial by jury, owner proved that power company's negligent maintenance of a transformer caused a fire that destroyed his restaurant. The jury returned a verdict for owner in the amount of $450,000 for property loss and $500,000 for emotional distress. The trial judge entered judgment in those amounts. Power company appealed that part of the judgment, awarding $500,000 for emotional distress. On appeal, the judgment should be A. Affirmed because power company negligently caused owners emotional distress. B. Affirmed because harm arising from emotional distress is as real as harm caused by physical impact. C. Reversed because the law does not recognize a claim for emotional distress incident to negligently causing property loss. Or D. Reversed unless the jury found that owner suffered physical harm as a consequence of the emotional distress caused by his property loss. Take 10 seconds and choose the best answer. If you chose C, reversed, because the law does not recognize a claim for emotional distress incident to negligently caused property loss, you'd be correct. If a plaintiff is physically harmed, she may recover not only for the physical damages, but also for all emotional and mental suffering that results from the physical impact. However, the law does not recognize a claim for emotional distress from negligently caused property loss. In this case, owner suffers property loss only as a result of the power company's negligence. So while the owner can recover for his property loss, he's not permitted to recover for any emotional distress. Remember, the law does not permit you to recover for emotional damages to any property, regardless of what that property may be. Question number 7. While browsing in a clothing store, Alice decided to take a purse without paying for it. She placed the purse under her coat and took a couple of steps towards the exit. She then realized that a sensor tag on the purse would set off an alarm. She placed the purse near the counter from which she had removed it. Alice has committed A. No crime because the purse was never removed from the store. B. No crime because she withdrew from her criminal enterprise. C. Only attempted larceny because she intended to take the purse out of the store. D. Larceny because she took the purse from its original location and concealed it with the intent to steal it. Take 10 seconds and choose the best answer. If you chose option D, you'd be correct. Larceny, because she took the purse from its original location and concealed it with the intent to steal. She also moved the item, in essence. So she lifted it and she relocated it, whether that may be one step away, whether that may be to her person. She, in essence, relocated the item. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. It is important to keep in mind that the slightest movement will satisfy this carrying away requirement. In this case, Alicia decided to take a purse without paying for it. She placed the purse under her coat and took a couple of steps towards the exit. This action by Alicia satisfies the elements for larceny, so Alice has in fact committed larceny. Question number 8. Bye-bye. Telegraph vendor on June 1st. At what price will you sell 100 of your QT model garbage disposal units for delivery around June 10th? Thereafter, the following communications were exchanged. Communication number 1. A telegram from vendor received by bye-bye on June 2nd. You're in luck. We have only 100 QTs on all clearance at 50% off usual wholesale of $120 per unit for delivery at our shipping platform on June 12th. Number 2. Communication number 2. A letter from bye-bye received in the U.S. mail by vendor on June 5th stating, I accept, would prefer to pay in full 30 days after invoice. Communication number 3. A telegram from vendor received by bye-bye on June 6th. You must pick up at our platform and pay COD. Communication number 4. A letter from bye-bye received in the U.S. mail by vendor on June 9th. I don't deal with people who can't accommodate our simple requests. Communication number 5. Telegram from bye-bye received by vendor on June 10th. After vendor had sold and delivered all 100 of the QTs to another buyer earlier that day. Okay, I'm over a barrel and will pick up the goods on your terms June 12th. Bye-bye now sues vendor for breach of contract. Which of the following arguments will best serve vendor's defense? A. Vendor's telegram received on June 2nd was merely a price quotation, not an offer. B. Bye-bye's letter received on June 5th was not an acceptance because it varied the terms of vendor's initial telegram. C. Bye-bye's use of the mails in response to vendor's initial telegram was an ineffective method of acceptance. D. Bye-bye's letter received on June 9th was an unequivocal refusal to perform that excused vendor even if the parties had previously formed a contract. Take 10 seconds and choose the best option now. If you chose option D, you'd be correct. Bye-bye's letter received on June 9th was an unequivocal refusal to perform that excused vendor, even if the parties had previously formed the contract. The rule is that where a party unambiguously states by words or conduct to the other party before the time to perform has arisen that she will not perform or that she is unable to perform, the other party is entitled to treat this as an anticipatory repudiation that generally excuses performance by the non-repudiating party. In this case, the letter from Bye-bye received in U.S. mail by vendor on June 9th states, "I don't deal with people who can't accommodate our simple requests," would be considered an unequivocal refusal to perform, which would excuse vendor even if the parties' previous communications were deemed a valid contract. As a result, D is the best option. Question number 9. In recent years, several large corporations incorporated in headquarters in State A have suddenly been acquired by out-of-state corporations that have moved all of their operations out of State A. Other corporations incorporated and headquartered in State A have successfully resisted such attempts at acquisition by out-of-state corporations, but they have suffered severe economic injury during those acquisition attempts. In an effort to preserve jobs in State A and to protect its domestic corporations against their sudden acquisitions by out-of-state purchasers, the legislature of State A enacts a statute governing acquisitions of shares in all corporations incorporated in State A. This statute requires that any acquisition of more than 25% of the voting shares of a corporation incorporated in State A that occurs over a period of less than 1 year must be approved by the holder of record of a majority of the shares of the corporation as of the day before the commencement of the acquisition of those shares. The statute expressly applies to acquisitions of State A corporations by both in-state and out-of-state entities. Assume that no federal statute applies. Is this statute of State A constitutional? Let's look at our 4 options. Option A, no, because one of the purposes of the statute is to prevent out-of-state entities from acquiring corporations incorporated and headquartered in State A. B, no, because the effect of the statute will necessarily be to hinder the acquisition of State A corporations by other corporations, many of whose shareholders are not residents of State A, and therefore it would adversely affect the interstate sale of securities. C, yes, because the statute imposes the same burden on both in-state and out-of-state entities wishing to acquire a State A corporation. It regulates only the acquisition of State A corporations, and it does not create an impermissible risk of inconsistent regulation on the subject by different states. D, yes, because corporations exist only by virtue of state law, and therefore the negative implication of the Commerce Clause does not apply to state regulations governing their creation and acquisition. Take 10 seconds and choose the best option. If you chose option C, yes, because the statute imposes the same burden on both in-state and out-of-state entities wishing to acquire a State A corporation. It regulates only the acquisition of State A corporations, and it does not create an impermissible risk of inconsistent regulations on this subject by different states. You'd be correct. If Congress has not acted, a state or local government may regulate local aspects of interstate commerce unless the state local laws discriminate against out-of-staters or place an undue burden on interstate commerce. Here, there is no such implication because in-staters and out-of-staters are all equally applied or equally affected. State or local laws that discriminate against out-of-staters are unconstitutional unless, 1, they achieve a goal that is necessary and important for the government, 2, there's been express congressional approval, or 3, the state or local government is a market participant favoring its own citizens. This law does not discriminate against out-of-staters, as we previously mentioned, so it can only be challenged under the Dormant Commerce Clause. However, since it does not discriminate against out-of-staters, it will only be held unconstitutional under the Dormant Commerce Clause if the statute places an undue burden on interstate commerce. Nothing in the facts indicates that approval of the majority of shareholders places any undue burden on interstate commerce. As a result, C would be the best option. And our final question for this grouping. In a jurisdiction without a dead man statute, Parker's estate sued Davison, claiming that Davison had borrowed from Parker $10,000, which had not been repaid as of Parker's death. Parker was run over by a truck. At the accident scene, while dying from massive injuries, Parker told Officer Smith to make sure my estate collects the $10,000 I loaned to Davidson. Smith's testimony about Parker's statement is inadmissible because it is more unfairly prejudicial than it is probative. B, inadmissible because it is hearsay not within any exception. C, admissible as an excited utterance. Or D, admissible as a statement under belief of impending death. Take 10 seconds and choose the best option. If you chose option B, inadmissible because it is hearsay, not within any exception, you'd be correct. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay is generally inadmissible because the declarant cannot be cross-examined when they speak out of court. Under the hearsay exception of excited utterances, a hearsay statement is admissible if it describes or explains an event or condition made while the declarant was perceiving the event or immediately thereafter. Another exception, the dying declaration exception, allows a hearsay statement made under the belief of impending death and describing the cause or circumstances leading to her impending death to be admitted in civil cases and homicide prosecutions only. In this case, Parker's statement was not an excited utterance because it was not a statement related to a startling event he had just experienced. Parker's statement also does not meet the requirements for the dying declaration exception because while made under the belief of impending death, Parker's statement did not describe the cause or circumstances leading to his impending death. As such, Parker's statement is not admissible because it is hearsay and not within any of the exceptions of hearsay. Thank you for joining us again on Bar 10, where it's our goal to help you prepare for the bar exam 10 questions at a time. Please like, subscribe, and click the notification bell so you can be updated every time we upload new content. It's our goal to upload new content every morning at 8 a.m. Eastern Standard Time. We hope to be with you from now until your successful passing of the bar exam.